Question 1. Trademark distinctiveness and secondary meaning. During a comprehensive review of a process that needs improvement, a company decides to rebrand its flagship product using a single descriptive term that directly conveys the nature of the product. The company has been using this term exclusively for the past 5 years in nationwide marketing campaigns and has spent millions of dollars in advertising. Despite this, the USTO examiner issued office action refusing registration on the basis that the mark is merely descriptive. Which of the following actions is the best legal argument to overcome this refusal? A. Filing an appeal, arguing that a descriptive mark does not require distinctiveness for registration. B. Submitting evidence proving that the mark has acquired secondary meaning due to long-term use and significant advertising expenditures. C. Modifying the mark by adding a generic term to make it more distinctive. D. Reapplying under a new class of goods or services where descriptiveness is not an issue. Answer B. Submitting evidence proving that the mark has acquired secondary meaning due to long-term use and significant advertising expenditures. Explanation. Under 15 U.S.C. SS 1052E, mark that is merely descriptive of the goods or services cannot be registered unless it has acquired secondary meaning, also known as acquired distinctiveness under 15 U.S.C. SS 1052F. Secondary meaning occurs when consumers associate the descriptive term specifically with the applicant's goods rather than its general meaning. Option is incorrect because descriptiveness alone does require distinctiveness for registration. Option C is incorrect because adding generic term e.g. Apple computers for company selling apples does not enhance distinctiveness. Option D is incorrect because simply reapplying under different class does not eliminate the descriptiveness issue for the same goods. Question 2. Likelihood of confusion and trademark infringement. In a high-stakes environment where multiple challenges arise, a new beverage company launches a drink called Coke Light. Soon after, the Coca-Cola company files a lawsuit claiming trademark infringement. The court applies the likelihood of confusion test and focuses primarily on which factor to determine infringement. A. The phonetic and visual similarity between a Coke Light and Coca-Cola and whether they create consumer confusion. B. The defendant's intent to adopt similar name, regardless of whether consumers are actually confused. C. The number of other companies using variations of the word Coke in their trademarks. D. The fact that Coke is a well-known mark, but the defendant claims to be using a light descriptively. Answer A. The phonetic and visual similarity between Coke Light and Coca-Cola and whether they create consumer confusion. Explanation. Under 15 U.S.C. SS 1114 and the Lanham Act, courts assess likelihood of confusion using factors outlined in the Polaroid test for the Second Circuit or the DuPont factors for the USTO. The key elements include similarity of the mark's appearance, sound meaning, strength of the plaintiff's mark, Coca-Cola is famous, strong mark, proximity of the goods, both are beverages. Actual consumer confusion not required, but strong evidence. Intent of the defendant, bad faith strengthens the case but is not dispositive. Option B is incorrect because intent alone does not establish infringement. Option C is incorrect because third-party use does not necessarily dilute strong mark like Coke. Option D is incorrect because descriptive use only applies when mark is not already famous and distinctive. Question 3. International trademark protection. Madrid system. During an emergency response where multiple areas are impacted, multinational corporation urgently seeks to secure trademark protection in multiple countries for its new pharmaceutical product. The company decides to file an international trademark application under the Madrid system. What is significant limitation of this approach? A. The Madrid system automatically grants protection in all member countries without further review. B. If the basic application or registration in the home country is cancelled within the first 5 years, all international registrations based on it will also be cancelled. C. The Madrid system only applies to trademarks for pharmaceutical and medical products. D. International trademark rights obtained through the Madrid system are superior to trademark laws in member countries. Answer B. If the basic application or registration in the home country is cancelled within the first 5 years, all international registrations based on it will also be cancelled. Explanation. The Madrid system, administered by WIPO, allows trademark holders to file a single international application that extends to multiple member countries. However, it has a major limitation known as the central attack rule under Article 6.3 of the protocol. If the home country's trademark application or registration is cancelled within 5 years, all international extensions automatically become void. This means that reliance on the home registration can be risky, as competitor may challenge the trademark in its country of origin, causing domino effect of invalidations worldwide. Option is incorrect because each designated country still examines the application based on its own trademark laws. Option C is incorrect because the Madrid system applies to trademarks across all industries, not just pharmaceuticals. Option D is incorrect because national trademark laws still prevail, meaning an international registration does not override local requirements. Question 4. During a comprehensive review of a process that needs improvement, a company discovers that its long-standing logo has become highly recognizable, but it has not been formally registered as a trademark. The company is concerned that competitors may attempt to copy or register similar logos. The legal team is tasked with determining whether the company's logo qualifies for trademark protection and how to proceed with registration. Following is the most accurate statement regarding the company's rights and the registration process. A. The company can immediately file trademark application with the United States Patent and Trademark Office (USTO) without proving any prior use or distinctiveness. B. The company's logo may qualify for protection under common law trademark rights, but federal registration would provide stronger legal presumptions and enforcement benefits. C. Since the company has not registered the logo, it has no enforceable rights, and any competitor freely use or register similar logo. D. Trademark protection applies only to word marks, not logos or designs, meaning the company would need to rely on copyright law instead of trademark law. Answer: B. The company's logo may qualify for protection under common law trademark rights, but federal registration would provide stronger legal presumptions and enforcement benefits. Explanation: under U.S. trademark law, unregistered trademarks may still have protection under common law rights, which arise from actual use in commerce. However, registering the logo with the USTO provides several legal advantages, including presumption of validity, ownership, and exclusive nationwide rights. While option B incorrectly states the company can file trademark without proving distinctiveness, logos often need to meet the distinctiveness criteria, such being arbitrary or fanciful. Option C is incorrect because common law rights do provide some enforcement power, though they are geographically limited. Option D is incorrect because logos and design marks can indeed be registered as trademarks. Question 5. While analyzing the root causes of sequential problems in brand enforcement, a multinational corporation discovers that several third-party sellers are marketing products under its brand name without authorization. The company is considering legal action for trademark infringement. Which of the following factors is the most critical in proving a case of trademark infringement under U.S. law? A. The alleged infringer used the brand name in any capacity, even if consumers are not confused. B. The corporation owns a registered trademark, but it must prove that the infringer's use creates likelihood of consumer confusion. C. Any unauthorized use of trademark automatically constitutes infringement, regardless of intent or confusion. D. Trademark rights only apply to physical goods, meaning the corporation cannot take action against online sellers. Answer: B. The corporation owns a registered trademark, but it must prove that the infringer's use creates likelihood of consumer confusion. Explanation: under the Lanham Act, 15 U.S.C. SS 1114, key requirement for trademark infringement is the likelihood of confusion test, which examines factors such as similarity of marks, strength of the plaintiff's mark, proximity of goods, and actual consumer confusion. Option A is incorrect because trademark infringement does not apply simply because a mark was used. There must be likelihood of consumer confusion. Option C is incorrect because intent alone does not automatically prove infringement, and certain defenses like nominative fair use may apply. Option D is incorrect because trademark rights apply to both physical and digital goods, and the corporation can take action against online infringers, particularly under the Anti-Cyber Squatting Consumer Protection Act (ACPA) and other enforcement mechanisms. Question 6. In a situation where formal requirements conflict with practical business needs, a fashion brand wants to register a unique shade of red as a trademark for its product packaging. However, the company is unsure whether a single color can be protected under trademark law. What must the company prove to successfully register the color as a trademark? A. The color must be inherently distinctive, meaning it is immediately recognized as a trademark without additional evidence. B. The company must demonstrate that the color has acquired secondary meaning and is not functional. C. The brand can only register a color as a trademark if no other business in any industry has ever used the color before. D. Trademark law does not allow registration of colors as they are considered too broad and functional protection. Answer B. The company must demonstrate that the color has acquired secondary meaning and is not functional. Explanation: trademark law does allow colors to be registered, but only if they have acquired secondary meaning and do not serve a functional purpose. This principle was established in Qualitex Company v. Jacobson Products Company, 1995, where the Supreme Court held that a single color could be trademarked if it identified the source of goods. Option A is incorrect because colors are not inherently distinctive. Option C is incorrect because prior use in a different industry does not necessarily prevent registration. Option D is incorrect because trademark law recognizes color trademarks, as seen in famous examples like Tiffany Blue and Laubautin Red Soles. Question 7. During the introduction of new methods where coordination between marketing and legal teams is crucial, a startup begins using a slogan heavily in advertisements. The team is debating whether to register the slogan as a trademark. Which of the following best describes the eligibility of a slogan for trademark protection? A. Slogans can only be registered if they include a company name or logo. B. The slogan must be distinctive and not merely a common phrase or advertising message. C. Trademark law does not protect slogans as they fall under copyright protection. D. Any slogan used in commerce is automatically protected as a trademark even without registration. Answer B. The slogan must be distinctive and not merely a common phrase or advertising message. Explanation: slogans can be protected as trademarks if they function as the source identifier and are not merely generic or descriptive phrases. For example, Nike's Just Do It is registered trademark because it has acquired distinctiveness. Option A is incorrect because slogan does not need to include company name or logo. Option C is incorrect because slogans typically fall under trademark law rather than copyright law. Option D is incorrect because unregistered slogans may have common law trademark rights, but federal registration provides stronger legal protections. Question 8. While examining inconsistencies across various units of a global brand, the legal team discovers that the company's registered trademark is being used inconsistently across different regions. Some logos differ slightly in design, and some brand names are altered. Which legal principle is most relevant in ensuring trademark rights are not weakened due to inconsistent use? A. The doctrine of trademark abandonment. B. The doctrine of fair use. C. The first sale doctrine. D. The nominative use doctrine. Answer A. The doctrine of trademark abandonment. Explanation: the doctrine of trademark abandonment states that if a trademark owner fails to consistently use a mark or allows uncontrolled variations, the mark may lose its distinctiveness and legal protection. This is why companies enforce strict brand guidelines. Option B is incorrect because fair use applies in limited situations where trademarks are used descriptively. Option C is incorrect because the first sale doctrine applies to resale of trademarked products, not inconsistent branding. Option D is incorrect because nominative use allows for reference to a trademark without confusion. Question 9. When implementing new protocols in a shared environment, a tech startup wants to use a generic term as its brand name, arguing that widespread recognition will make it a strong trademark. Which of the following is true regarding generic terms as trademarks? A. Generic terms can never receive trademark protection, regardless of their popularity. B. A generic term can be registered if it acquires secondary meaning through extensive use. C. If a company is the first to use a generic term, it can claim exclusive rights. D. The USTA will allow registration of generic terms if they are used in combination with a unique logo. Answer A. Generic terms can never receive trademark protection regardless of their popularity. Explanation: generic terms can never be registered as trademarks because they refer to the common name of a product or service, and granting exclusive rights would prevent fair competition. This principle was upheld in Booking.com v. United States Patent and Trademark Office 2020, where the Supreme Court ruled that a term combined with a top-level domain.com may qualify for protection, but the term itself remains unregisterable. Option B is incorrect because secondary meaning applies to descriptive marks, not generic ones. Option C is incorrect because first use does not override genericness. Option D is incorrect because while logos may be registered separately, the term itself remains unprotectable. Question 10. During an in-depth analysis of market trends, a company realizes that its brand name is being used by an unrelated business in a different industry. The company wants to take legal action but is unsure if trademark law applies in this situation. Which of the following is the most important factor in determining whether trademark infringement has occurred? A. The similarity of the trademarks and whether the use causes a likelihood of consumer confusion. B. The fact that the company was the first to register the trademark regardless of how the other business is using the name. C. Whether the other business is profiting from using a similar name even if the industries are completely unrelated. D. If the company has an international trademark, it automatically prevents any use of the name by other businesses. E. Different industries. Answer A. The similarity of the trademarks and whether the use causes a likelihood of consumer confusion. Explanation: trademark infringement is determined by the likelihood of consumer confusion, which is assessed based on factors such as the similarity of the marks, the relatedness of the goods or services, and the strength of the original trademark. Option B is incorrect because merely being the first to register a trademark does not guarantee exclusive rights in all industries. Trademark rights are often limited to specific classes of goods and services. Option C is incorrect because profit alone is not the determining factor in infringement cases. Confusion must be demonstrated. Option D is incorrect because international trademark protection is not automatic and trademarks are typically enforced within specific jurisdictions and industries. Question 11. While reviewing the impact of new policies in a competitive market, a corporation discovers that a competitor is using a very similar logo with slight modifications. The competitor argues that small design changes mean there is no infringement. Which of the following best explains whether the original company can still pursue legal action? A. Minor modifications to a trademark do not automatically prevent a claim of infringement if they still create a likelihood of confusion. B. A competitor can legally use a similar logo as long as it makes any changes, no matter how small. C. If the competitor's logo is not an exact copy, there is no legal basis for trademark infringement claim. D. Trademark protection only applies to names and words, not logos or designs. Answer A. Minor modifications to a trademark do not automatically prevent a claim of infringement if they still create a likelihood of confusion. Explanation: trademark infringement is based on the overall commercial impression a mark creates, rather than exact duplication. Even minor changes may not be sufficient to avoid confusion if consumers could mistake the competitor's logo for the original brand. Courts consider factors such as the appearance, sound, and meaning of the marks in determining infringement. Option B is incorrect because small modifications do not automatically eliminate the risk of confusion. Option C is incorrect because trademark infringement does not require exact copying. It is based on likelihood of confusion. Option D is incorrect because logos, symbols, and distinctive designs can absolutely be protected under trademark law. Question 12. As part of the process of evaluating risk and legal exposure, a retail company learns that a competitor has been using a nearly identical brand name for years, but in a different region. The company wants to enforce its trademark rights. What is the most important factor in determining whether the company can successfully challenge the competitor's use of the name? A. Whether the company has federally registered trademark that predates the competitor's use. B. If the competitor has been using the name in another region, the original company automatically loses its trademark rights. C. Trademark protection only applies within the state where the business is originally registered. The competitor can use an identical brand name if they are selling different types of products. Answer A. Whether the company has a federally registered trademark that predates the competitor's use. Explanation: having federally registered trademark gives the company nationwide protection and legal presumption of ownership and priority. If the company's registration predates the competitor's use, it has a strong case for enforcing its rights. However, if the competitor was using the name before the federal registration, they may have common law rights in a specific region. Option B is incorrect because federal trademark does not automatically become invalid due to regional use by another company. Option C is incorrect because federal trademarks provide protection across all U.S. states. Option D is incorrect because even different products can still lead to brand dilution or confusion, especially if they are related in some way. Question 13. While refining corporate branding strategies, a business decides to use a celebrity's name in its advertising campaign without their permission. The celebrity files lawsuit, claiming unauthorized use of their identity. Which legal principle is most relevant in this case? A. The right of publicity, which protects a person's name, image, and likeness from unauthorized commercial use. B. Fair use, which allows businesses to use public figures in advertisements without permission. C. The first sale doctrine, which permits the resale of products featuring celebrities' image. D. Nominative fair use, which allows businesses to reference celebrities' name as long as it is not misleading. Answer A. The right of publicity, which protects a person's name, image, and likeness from unauthorized commercial use. Explanation: the right of publicity protects individuals, particularly celebrities, from unauthorized commercial use of their name, image, voice, or likeness. This prevents businesses from profiting from persons' identity without consent. Option B is incorrect because fair use does not cover commercial exploitation of celebrities' identity. Option C is incorrect because the first sale doctrine applies to resale of goods, not advertising use of person's image. Option D is incorrect because nominative fair use applies only when referencing celebrities' name truthfully and not as an endorsement. Question 14. During the implementation of compliance measures across multiple regions, a corporation finds that one of its subsidiaries has been using a brand name that is already registered by another company. Which of the following best describes the potential legal consequences? A. The subsidiary may be required to stop using the name if it creates a likelihood of consumer confusion. B. If the subsidiary is part of a larger corporation, it is automatically allowed to use any brand name. C. The fact that the subsidiary operates in a different market means there are no legal consequences. D. The registered trademark owner must prove intentional copying to stop the subsidiary's use of the name. Answer A. The subsidiary may be required to stop using the name if it creates a likelihood of consumer confusion. Explanation: trademark rights prevent unauthorized use that creates consumer confusion, even if the subsidiary operates in a different market. If the original company can show likelihood of confusion, it can enforce its trademark. Option B is incorrect because corporate structure does not override trademark laws. Option C is incorrect because even different industries can have overlapping trademark concerns, especially if brand dilution occurs. Option D is incorrect because intentional copying is not required to prove infringement. Only confusion matters. Question 15. As part of an effort to expand into a new market, a company wants to register a new trademark. However, it discovers that a similar mark has already been registered but is not currently being used in commerce. What legal principle would determine whether the prior trademark holder retains their rights? A. The concept of trademark abandonment, which states that a trademark can be lost if not actively used. B. The first to file rule, which gives priority to whoever registered the mark first, regardless of use. C. The fair use doctrine, which allows the new company to use the mark as long as they distinguish it sufficiently. D. The dilution doctrine, which protects famous trademarks from being used by others in any industry. Answer A. The concept of trademark abandonment, which states that a trademark can be lost if not actively used. Explanation: under U.S. trademark law, a trademark can be considered abandoned if the owner has ceased using it in commerce for 3 consecutive years with no intent to resume use. In this case, if the original trademark holder has not actively used the mark, the company may be able to challenge its validity and proceed with registration. Option B is incorrect because trademarks require actual use in commerce to be enforceable. Option C is incorrect because fair use applies to descriptive or comparative use, not registration conflicts. Option D is incorrect because the dilution doctrine applies only to famous trademarks, and this situation does not involve a dilution claim. Question 16. While developing a new product line, a company receives a cease and desist letter from a competitor claiming that the product's name infringes on their trademark. The company believes the competitor's trademark is too generic to be enforceable. What is the most relevant legal principle in this situation? A. Generic terms cannot be trademarked because they describe category of goods rather than a specific brand. B. Any registered trademark is automatically enforceable regardless of how generic it may seem. C. The new company must prove that customers are not confused to continue using the product name. D. If the competitor has federally registered trademark, the company must change its product name immediately. Answer A. Generic terms cannot be trademarked because they describe a category of goods rather than a specific brand. Explanation: a generic term is one that refers to an entire category of goods, e.g., apple for apples, and cannot be trademarked. If the competitor's trademark is found to be generic, it loses protection and cannot be enforced. Option B is incorrect because trademark can be challenged and invalidated if it becomes generic. Option C is incorrect because consumer confusion is irrelevant if the term is generic. Generic terms are never enforceable as trademarks. Option D is incorrect because having federal registration does not guarantee that trademark is valid if it is generic. Question 17. A startup company is preparing to launch a new product and wants to trademark its brand name. However, the name describes a key characteristic of the product. Which of the following best explains the challenges the company might face in securing trademark protection? A. Descriptive trademarks are difficult to register unless they acquire secondary meaning in the marketplace. B. Any brand name can be trademarked as long as it is not identical to an existing registered trademark. C. A company can freely register a descriptive trademark without additional requirements. D. Descriptive trademarks are given the strongest level of protection under trademark law. Answer: A. Descriptive trademarks are difficult to register unless they acquire secondary meaning in the marketplace. Explanation: descriptive trademarks directly describe a product's characteristics, e.g., cold ice for an ice company. These marks are not automatically protectable unless they acquire secondary meaning, meaning consumers recognize the name as associated with a specific business rather than just describing the product. Option B is incorrect because distinctiveness, not just uniqueness, determines trademark eligibility. Option C is incorrect because descriptive marks are weak and often require additional proof of consumer recognition. Option D is incorrect because fanciful, arbitrary, or suggestive trademarks receive the strongest protection, not descriptive ones. Question 18. In response to growing competition, a company redesigns its logo but retains some key elements of its original design. It also decides to update its trademark registration. What is the most important legal consideration when updating a trademark registration? A. A trademark registration must accurately reflect how the mark is currently being used in commerce. B. Once a trademark is registered, it does not need to be updated, even if the design changes. C. A company can use any version of its logo without updating the registration as long as it owns the original trademark. D. The company can continue to enforce its trademark rights even if it never updates the registration. Answer: A. A trademark registration must accurately reflect how the mark is currently being used in commerce. Explanation: trademark owners must ensure that their registered trademark matches the version currently used in commerce. If significant changes are made, the new version may not be covered by the existing registration, requiring an update or a new application. Option B is incorrect because a trademark must reflect actual use to remain valid. Option C is incorrect because substantial changes to a trademark could affect its enforceability. Option D is incorrect because failure to use and maintain an accurate registration could weaken enforcement rights. Question 19. A well-known fashion brand discovers that a third-party seller is using its brand name on counterfeit products sold online. The brand wants to take action against the seller. What is the most effective legal remedy in this case? A. Filing a trademark infringement lawsuit and seeking an injunction to stop the counterfeit sales. B. Allowing the seller to continue operating as long as they use a disclaimer stating the items are not genuine. C. Ignoring the counterfeit sales unless they directly impact the brand's primary retail locations. D. Contacting the seller and asking them to voluntarily stop selling the counterfeit goods without taking legal action. Answer: A. Filing a trademark infringement lawsuit and seeking an injunction to stop the counterfeit sales. Explanation: counterfeit goods directly violate trademark laws by misleading consumers into thinking they are purchasing authentic products. The best legal remedy is to file a trademark infringement lawsuit and seek an injunction to halt sales. Option B is incorrect because disclaimers do not necessarily prevent consumer confusion or make counterfeiting legal. Option C is incorrect because brands must actively protect their trademarks or risk weakening their legal rights. Option D is incorrect because legal action is often necessary to effectively stop counterfeiting. Question 20. In a high-stakes environment where multiple challenges must be addressed simultaneously, a company is expanding into a new market and wants to protect its brand through trademark registration. However, it discovers that a local business has been using a similar name without registration. What legal options does the company have to secure its trademark rights in this jurisdiction? A. The company can register its trademark and automatically prevent the local business from continuing to use its name. B. The local business retains priority over the name since it was using it first even without registration. C. The company can challenge the local business's use if it can prove likelihood of consumer confusion. D. Trademark protection does not apply in new markets where a company has never done business before. Answer: C. The company can challenge the local business's use if it can prove likelihood of consumer confusion. Explanation: trademark law prioritizes first use in commerce, meaning that even without registration, the local business may have common law rights if they can prove prior use. However, if the new company can show consumer confusion and obtain federal or local registration, it may be able to challenge the local business's continued the name. Option A is incorrect because registration does not automatically cancel prior rights. Option B is partially correct but does not account for potential legal challenges. Option D is incorrect because trademarks can apply in new markets if confusion is likely. Question 21. During a major transformation where existing methods of brand enforcement are being revised, a company wants to strengthen its trademark protections by registering in multiple countries. What is the most effective legal strategy for international trademark registration? A. File separate trademark applications in each country based on local laws. B. Rely on the company's existing U.S. trademark to automatically apply worldwide. C. Use the Madrid system to file a single international trademark application. D. Register the copyright instead, since trademarks only apply domestically. Answer: C. Use the Madrid system to file a single international trademark application. Explanation: the Madrid system allows companies to file one international trademark application that can be extended to multiple member countries, simplifying the process. Option A is incorrect because, while possible, it is costly and time-consuming. Option B is incorrect because US trademarks do not grant automatic international rights. Option D is incorrect because copyright and trademark laws are different and copyright does not protect brand names or logos in the same way. Question 22. While investigating a complicated issue between different companies over similar branding, a court must determine whether one business has infringed upon another's trademark. What is the key factor in determining trademark infringement? A. Whether the trademarks are visually identical. B. Whether consumers are likely to be confused by the two brands. C. Whether the first company had its trademark registered first. D. Whether both businesses operate in the same geographic location. Answer: B. Whether consumers are likely to be confused by the two brands. Explanation: the primary test for trademark infringement is the likelihood of consumer confusion, meaning whether consumers would mistakenly associate one brand with another. Option A is incorrect because marks do not need to be identical to cause confusion. Option C is incorrect because registration helps but does not always guarantee protection. Option D is incorrect because even businesses in different regions can infringe if their markets overlap online or nationally. Question 23. When implementing new protocols in a shared environment where multiple brands coexist, a company is accused of trademark dilution by a well-known competitor. What does trademark dilution mean, and under what circumstances does it apply? A. Trademark dilution occurs when a similar name is used even if no confusion exists and it weakens a famous brand's uniqueness. B. Trademark dilution only applies if the new brand is directly competing with the famous brand. C. Trademark dilution means a trademark owner has abandoned their mark by failing to enforce it. D. Trademark dilution does not apply if the new company legally registers its mark first. Answer: A. Trademark dilution occurs when a similar name is used even if no confusion exists and it weakens a famous brand's uniqueness. Explanation: trademark dilution occurs when a famous brand's distinctiveness is weakened even if there is no direct competition or consumer confusion. This can happen through blurring, reducing uniqueness, or tarnishment associating the brand with something negative. Option B is incorrect because dilution applies even in unrelated industries. Option C is incorrect because dilution is different from abandonment. Option D is incorrect because prior registration does not eliminate dilution claims against famous brands. Question 24. In a scenario where efficiency decreases across multiple business units due to legal disputes, a company faces a lawsuit claiming trade dress infringement. What does trade dress protection cover? A. The overall appearance and design of a product, including packaging and layout. B. Only the logo and brand name of a company. C. Any words or symbols used for advertising, regardless of design. D. The company's slogan or marketing materials. Answer: A. The overall appearance and design of a product, including packaging and layout. Explanation: trade dress refers to the visual appearance of a product, such as its packaging, design, or even store layout, that helps consumers identify its source. Option B is incorrect because logos and brand names are trademarked separately. Option C is incorrect because trade dress requires distinctive design elements. Option D is incorrect because slogans are protected under trademark law, not trade dress. Question 25. During a seamless transition where continuity must be maintained, a company is rebranding but wants to retain its previous customers' loyalty. What legal steps should the company take to protect its old brand identity while transitioning to the new one? A. Maintain dual trademarks for both the old and new brands during the transition. B. Immediately abandon the old brand name and focus only on marketing the new one. C. Allow other businesses to use the old brand name freely after transitioning. D. Transfer all trademarks to new entity and start over. Answer: A. Maintain dual trademarks for both the old and new brands during the transition. Explanation: a company should not immediately abandon its old brand name. Maintaining dual trademarks allows for a smoother transition while preventing competitors from taking advantage of the brand equity built under the old name. Option B is incorrect because this would cause customer confusion. Option C is incorrect because allowing others to use the old name risks loss of brand identity. Option D is incorrect because starting over unnecessarily weakens trademark rights. Question 26. When scaling up operations that experience significant brand exposure, a company wants to enforce its trademark rights against international counterfeiters. What is the best legal action to take? A. File a lawsuit under the Lanham Act and work with customs enforcement. B. Only focus on removing counterfeit products from online marketplaces. C. Send cease and desist letters to counterfeit sellers and take no further action. D. Register a copyright instead of enforcing trademark rights. Answer: A. File a lawsuit under the Lanham Act and work with customs enforcement. Explanation: the Lanham Act provides a basis for lawsuits against counterfeiters in the U.S. Customs enforcement can seize counterfeit goods before they enter the country. Option B is incorrect because only targeting online sales is insufficient. Option C is incorrect because counterfeiters often ignore cease and desist letters. Option D is incorrect because copyright does not protect brand identity like a trademark does. Question 27. In an environment where different components must interact seamlessly, a global corporation acquires a smaller company with an established brand. The corporation wishes to integrate the acquired company's branding while ensuring legal protection. What steps should the corporation take to legally secure and merge the acquired brand? A. Immediately discontinue the acquired company's trademarks and rebrand everything under the corporation's name. B. Maintain the acquired company's trademarks while gradually introducing co-branding strategies. C. Let the acquired company's trademarks expire and file new applications under the corporation's name. D. Ignore the acquired company's existing trademarks since ownership automatically transfers after acquisition. Answer: B. Maintain the acquired company's trademarks while gradually introducing co-branding strategies. Explanation: when company acquires another business with an established brand, it is crucial to maintain existing trademarks to preserve brand value and prevent consumer confusion. Option A is incorrect because sudden discontinuation can lead to brand dilution and loss of goodwill. Option C is incorrect because allowing trademarks to expire may open them up to third-party claims. Option D is incorrect because trademarks must be properly transferred through legal documentation to ensure continued protection. Question 28. During the introduction of new methods where coordination between departments is essential, a company discovers a competitor using a confusingly similar slogan in marketing campaigns. How should the company proceed to protect its brand? A. File a lawsuit immediately without considering prior use. B. Conduct a trademark search to determine whether the slogan was previously registered. C. Ignore the issue unless customer complaints increase. D. Assume the competitor's use is legal since slogans cannot be trademarked. Answer: B. Conduct a trademark search to determine whether the slogan was previously registered. Explanation: the first step in trademark enforcement is conducting a trademark search to determine if the company's slogan has prior registration and protection. Option A is incorrect because lawsuit without proper research can lead to unnecessary legal costs. Option C is incorrect because ignoring the issue risks weakening trademark rights. Option D is incorrect because slogans can be trademarked if they are distinctive and not generic. Question 29. When implementing backup procedures across various markets, a company notices unauthorized third-party sellers using its brand name to sell similar products online. What legal action should the company take to prevent unauthorized use of its trademark? A. File a Digital Millennium Copyright Act (DAA) complaint to remove the unauthorized listings. B. Issue cease and desist letters, and if ignored, pursue legal action under the Lanham Act. C. Allow the third-party sellers to continue as it increases brand exposure. D. Buy out the unauthorized sellers instead of taking legal action. Answer: B. Issue cease and desist letters, and if ignored, pursue legal action under the Lanham Act. Explanation: trademark owners must actively enforce their rights to prevent unauthorized use. Cease and desist letters are the first step, followed by legal action under the Lanham Act if infringement continues. Option A is incorrect because the DSEA applies to copyright violations, not trademark. Option C is incorrect because allowing unauthorized use can lead to brand dilution and consumer confusion. Option D is incorrect because purchasing unauthorized sellers does not provide long-term brand protection. Question 30. In a situation where resource allocation becomes increasingly complex, a company licenses its brand name to third-party manufacturers. What is the most important legal consideration when structuring a brand licensing agreement? A. The licensing agreement should clearly define quality control measures to protect the brand's reputation. B. The company should grant unrestricted use of the brand name to allow maximum flexibility. C. Licensing agreement is unnecessary since the company retains ownership of the trademark. D. The company should only license its brand name to single entity to avoid market confusion. Answer: A. The licensing agreement should clearly define quality control measures to protect the brand's reputation. Explanation: quality control provisions are crucial in brand licensing agreement to ensure that third-party manufacturers maintain the brand's reputation. Option B is incorrect because unrestricted use can lead to brand dilution. Option C is incorrect because licensing agreements must be legally documented to outline rights and obligations. Option D is incorrect because exclusive licensing is not always necessary. Multiple licenses can be allowed if properly managed.